Section 11 of the Equality Act states that in relation to the protected characteristic of sex, a reference to a person who has a particular protected characteristic is a reference to a man or to a woman. And Section 212 states that a woman means a female of any age. The definition of sex in the Act is therefore essentially based on biology. However, there is some ambiguity about this because for some purposes, trans-identifying males with the GRC are treated as if they're women under the Equality Act, but for other purposes, they're not. Section 7 of the Act states that a person has the protected characteristic of gender reassignment if they are proposing to undergo, have undergone a process or part of a process for the purposes of reassigning their sex by changing physiological or other attributes of sex. It doesn't involve or have to involve any changes to the body. None of the legislation does involve any requirements for changes to the body in order to change legal gender. By separating the protected characteristic of sex and the characteristic of gender reassignment, and by including separate definitions of each of them, the Equality Act makes a reasonably clear distinction between sex and gender, despite its ambiguities. It includes exceptions which allow trans-identifying males to be treated differently from women in some circumstances, whether or not they have a gender recognition certificate, provided that the differential treatment pursues a legitimate aim and does so in a proportionate way. Trans-identifying males can be excluded from single-sex services, such as domestic abuse services, and they can be excluded from sleeping facilities in communal accommodation. The job can be restricted to women only if being a woman is considered an essential requirement for the role. And that could include a job which involves providing services specifically to female survivors of domestic or sexual violence, for example. Trans-identifying males can also be excluded from women's single-sex sports if this is necessary to ensure fair competition or the safety of competitors. In most sports, it will be necessary to do either one of those things or both of them. Trans-identifying males who don't hold a gender recognition certificate can be excluded from single-sex associations or clubs and from all women shortlists. Those with a GRC can't be excluded from those two things because for these purposes, they're treated as being a member of their acquired gender or sex. For the past 10 years or so, groups in the UK who lobby for self-declaration of gender identity in law, or self-ID, have been trying, often very successfully, to blur the distinctions between sex and gender reassignment in law. Many of them provide training and consultancy to both public and private sector organisations. And while doing so, they often remove sex from the list of protected characteristics that they use, and they replace it with gender. They've been doing that for some years now. And there's been a process of policy capture by lobby groups, which has led to the introduction of self-ID in practice in many organisations, including criminal justice agencies, the police service, and the prison service, and the courts. Some domestic abuse and rape crisis centres in the UK use the Equality Act exemptions to maintain women-only services. But many have started to provide services to trans-identifying males with and without gender recognition certificates. In some cases, this is because of confusion about the law, and the law in this area is confusing, or because they're under threat of having their funding withdrawn if they don't provide services to males. Sometimes the funder's requirement is that they provide services to any males, and sometimes it's to trans-identifying males specifically. In other cases, though, it's because the organisation's leadership has accepted the mantra that trans women are women. In recent years, reforms to the GRA which would introduce self-ID have been proposed in England and Wales and in Scotland. And there have been public consultations about these proposals in both jurisdictions. These consultations gave feminists the opportunity to organise against self-ID, unlike in many other countries where it's been introduced by stealth. While campaigning against self-ID in law, we've discovered how widespread self-ID has become in practice.